Hi, welcome to a new episode of Meet the Guest Lecture. Today I have the pleasure of talking with Dr. Ciara Smyth, who's the Program Director in the International Migration and Refugee Law and Policy, LL.M, at the Irish Centre for Human Rights at the University of Galway. Today you came to talk to our students about the protection of unaccompanied minor in the upcoming European Migration and Asylum Pact. My first question for you would then be, could you tell us a bit what is, in your opinion, the biggest challenge for children's rights in this area?
Oh, that's a big question. So it's hard to know where to start with that because there are so many provisions in the Pact that are new in terms of dealing with children's rights and dealing with unaccompanied minors. But certainly one of the biggest challenges is around the whole issue of age assessment, because in order for children to benefit from the additional procedural and reception guarantees that they get in the Pact, for unaccompanied minors to benefit from that, they have to be first identified as unaccompanied minors. And very often this comes down to age assessment. So the Pact says that, the Asylum Procedures Regulation specifically, says that age assessment should only be carried out in cases of doubt. And that's already very helpful because previously what we tended to see was a standardised practice whereby anyone that claimed to be an unaccompanied minor, even if it was completely obvious that they were a child, would be age assessed. And now the Pact is quite clear that it's actually only where it's in doubt, where the age of the child is in doubt, that age assessment is carried out. But there are some ambiguities in the Pact about the age assessment. So, for example, it says that the age assessment should be conducted by a multidisciplinary team. So we don't know, because the Pact doesn't tell us exactly what that means. And in Ireland, and I know in the Netherlands also, there is a discussion at parliamentary level at the moment about who should this multidisciplinary team be? How should they be composed? Is it composed, for example, of 2 people? Does that mean multidisciplinary? Or is it a full team of maybe 5 or 6 persons? And what professions should they come from to do an age assessment? So should it be a child psychologist? Should it be a doctor or a nurse or some other medical practitioner? For example, should it be a social worker? Or indeed, as one of the students suggested today, should it be a member of the police who has, a background in forensics and can maybe examine fingerprints or whatever it might be? So this is left open to member states. So that is slightly worrying because it could be whittled down to being not very meaningful. And so that's the first thing. And then the other concerning thing in the Pact from an age assessment point of view, well, there's 2 other things. One is the whole issue that unaccompanied minors are, they're meant to give their consent to any kind of medical age assessment. But if they don't consent to it, then that generates a presumption that they're not minors. And so if there's a negative consequence that comes from not consenting, that really potentially vitiates the consent and raises the question whether it's really truly informed consent that they're giving. So that's problematic. And then the whole issue of medical age assessment. So the Pact says that when the multidisciplinary age assessment that we just talked about, when that's inconclusive, that member states can proceed to a medical age assessment. But the problem with medical age assessment, there's a couple of problems. Sometimes they're unethical. So one example would be your wrist bone x-ray, that's very typical, or a dental x-ray to see whether the molars have erupted. Those obviously involve using x-rays, and that can be counterindicated when x-rays are used for a non-medical purpose. So ethically, it's questionable. But also those medical methods come with a margin of error of plus or minus about 18 months. So if we agree that you're only meant to be conducting age assessments on people that you can't ascertain are unaccompanied minors, well, they're already going to be borderline. And then you have a plus or minus margin of error of 18 months. What does that give you in the end? Are we still not exactly where we started off with a high degree of uncertainty about the age of the applicant? So these are all concerns that are not clearly ironed out in the Pact and that member states are going to have to figure out for themselves, obviously subject to the jurisdiction of the Court of Justice.
Yeah, thank you. I think what I'm curious then is maybe what perspective or experience you specifically bring to this topic and to the international LL.M in human rights law and children's rights law that we have here. Kind of what was the purpose of your talk today?
Well, in terms of my own background, I'm actually an alumnus of the University of Leiden because I did my PhD here many years ago under the direction of Peter Boulez, who's subsequently retired. So I feel, in my heart, very close to Leiden University and the LL.M here. But also I am the programme director of a similar LL.M in the University of Galway in the Irish Centre for Human Rights, which is the LL.M in International Migration and Refugee Law, which you mentioned. So actually we're teaching about a lot of the same stuff, although we don't have a specific focus on children's rights. Because of my sort of research interest in children's rights, I do bring a lot of children's rights topics to bear on our students back in Galway. So in terms of my own research interests, I have a wide range of interest in all sorts of migration-related issues as they pertain to children. So we've talked about age assessment, that's one of them, but also the adaptation of asylum procedures for unaccompanied minors, because they are going to be interviewed, on their own behalf. They don't just fall within somebody else's application. So things like, how do you interview an unaccompanied minor? And how do you take a definition that was really scripted for adults and make it meaningful for children? How do you integrate the rights of the child into that definition? How do you tailor asylum procedures for children? And then another big interest of mine is the immigration detention of children, and what exactly are the legal standards that pertain to the immigration of detention of children. So actually we talked about all these things in our class today.
Yeah. And I think maybe a last note, if you have a final message for the students of the program and maybe the alumni of the program and the future students of the program that you would leave them with.
Well, I mean, we're living at a particular historical moment that can be challenging for people because it does seem quite hopeless. And certainly when you read the EU Pact on Migration and Asylum and its provisions on unaccompanied minors and other children, the tendency is to despair a little bit, I think. But my message, I suppose, is it's up to us as lawyers to find the clever legal tactics and to find the possibilities within legal texts. And to exploit those possibilities to advance the rights of the child. And I think there are parts of the Pact that could be positively construed, and it's up to us as lawyers to find them and to exploit them to the best of our ability.
Thank you. I think that's very positive and a good message to end with. I thank you a lot for coming, for talking to the students today, and for doing this with us. And I thank everyone for watching this, and I look forward to the next episode of this series.